Thank you for joining us. Throughout the webinar, if you could please remain on mute, and for the best experience, please select speaker view. Hopefully you should all be familiar with the software, to which there is a question box down the right hand side. Obviously you can submit questions throughout the presentation, to which then myself and Ellis will answer these at the end. The webinar will also be recorded and then published online for anyone who is obviously unable to attend today. As you can see, I've got my colleague Ellis Lake with me, who a number of you will be familiar with. Ellis works with myself within our professional practices team. She's presented on numerous of these webinars with me and has vast experience in this field. With regards to the format, we've got 4 sections which we just want to talk through today, which will then be followed by the question and answer slot at the end. Ellis is going to cover the solicitors' accounts rules and an update on these, along with the basis period reform, which is just around the corner now. I will then talk through a little bit of business strategy, most notably in relation to ESG. So I'll now hand over to Ellis. Thank you.
Thank you, John, and good afternoon, everybody. Nearly said good morning then. Firstly, today I'm going to just have a brief chat on the SRA accounts rules and updates that have come out recently, and then I'm going to move on to the basis period reform and chat about what that is firstly and what that means for your business. So the SRA accounts rules, they've been in place now for nearly 3.5 years. They were introduced on the 25th of November 2019. Hopefully you are familiar with them now and are working internally to see how best that they can work for you and your firm. We would expect businesses now to be looking at the rules and seeing how you can use them to modernise your approach internally and make the rules fit your business rather than making your business fit the rules. We have seen a number of contacts and clients still using the 2011 rules, which I say they're old rules, but I say the 2019 rules are new rules, but I guess they aren't actually too new anymore. Anyway, I guess the message is just have a look at your policies and see if there's anything that is causing you a bit of a headache that you could amend and modernise your approach. So, and I have discussed that on previous webinars, so I'm not going to reflect too much on that today. The changes in the rules themselves, there hasn't been too many, but the SRA have recognised that there are teething problems with some of the rules that have been introduced, and they've already issued various bits of guidance in relation to some of these points. There has been a further consultation recently, so it closed at the end of this month, which focused on a number of areas. The 3 main key areas I think that are relating to the accounts rules are on the screen there. So we've got taking money for costs, reimbursing for disbursements, and operation of a client's own account. So I think the message is that there's more, probably more guidance coming from the SRA on some of these areas. Once we've got the results of the consultation, then we'll look to review those either on another webinar or on a blog on our website, so do look out for that. I think it just shows that the SRA are still willing to work with law firms and they don't want to put a burden on you. They want to make your lives easier with the ultimate aim of keeping client money safe, of course. So that was just a brief touch on that. There has been quite a bit more guidance issued in relation to banking facilities. So on the SRA's website, within the guidance section, there are already a number of case studies in relation to banking facilities, and the SRA have recently published 5 more. So I was just going to have a look at those today in turn, just to run through them. The banking facility rule 3.3 basically states that solicitors cannot provide banking facilities to clients, and the update of issuing new case studies to this area reaffirms the SRA's position on it, that they really do not take kindly to this sort of stuff, and they do view it as a really serious breach. So if we just have a look at the case studies in turn, the first one is lender's condition on a mortgage offer. So this is whereby there might be a condition of a mortgage offer which specifies that another debt needs to be repaid before the mortgage is released, for example. And in that scenario, if it's a condition of the offer, that wouldn't be classified as providing a banking facility because the transaction is related to the matter specifically. The second one is legal advice only retainers. So the example on this one gives where, say, a firm is advising on an SDLT matter for a client, but they didn't transact or they didn't act for the property purchase. So in that situation, the example states that the client wanted the firm to pay the SDLT on their behalf, so they would forward the money and the legal firm would pay it on to HMRC. As that had no connection to the advice that that firm was providing whatsoever, in that scenario there would be a breach of 3.3. So just things to look out for and make sure that any transaction that's passing through the client account is in relation to the regulated service that you are providing. Just moving on, so third one to go through, this looks at where there's a divorce matter and a sale of the matrimonial home. So for example, the family home may have been sold and you've got net sale proceeds sitting on the client account, but there hasn't been an agreement reached yet in relation to how the funds are going to be distributed, and maybe there's other assets to sort out as well. If there's not a court order yet to explain how the proceeds should be distributed between the parties, the SRA don't consider there to be a breach of Rule 3.3, so a firm can hold on to the money. So you might see this where if you're looking at matters, I know you can run reports on your system that haven't moved for a period of time. So this could be an example. If the proceeds are sitting there and there hasn't been any movement, that would be a justifiable reason. Just flying through the next one. So we've got parent paying a child's legal fees. So for example, parent has a matter with one fee earner in the firm, and then their child has instructed another fee earner in the firm on a completely separate matter. It is possible for monies to be held on the parent's matter to pay for the client's, for the child's bill on the other matter. Sorry, I can't get my words out. So yeah, so that's okay. So you can move monies between matters to settle fees as long as both parties agree to that and there aren't any other red flags. There's warning notices about this on the SRA's website, so do have a look at that if you are unclear. And the last one is in relation to conveyancing and retentions, and I know this is quite a hot topic, lots of questions around this, and usually where a retention is held as part of a conveyancing matter, there won't be a breach of Rule 3.3 in the SRA's view. Ordinarily, the money for a retention wouldn't be required to be held for long, although the SRA acknowledge that there are instances whereby balances are held for longer. And I think in those instances where the retention is being held for longer, as long as you are reviewing the matter on a regular basis and continually questioning whether you should still be holding the funds or not, then that's okay to still hold if applicable to do so. So that's just sort of a brief overview of the additional case studies. Like I say, there are more on the SRA's website, so do have a look at those. just sort of some action points following from that, so sort of some practical advice to give you. I guess the main message here is that each matter is individual and the circumstances on each case should be reviewed in turn. It's what we don't want you to be doing, what the SRA don't want you to be doing, is sort of shoehorning a situation that you may have into one of the examples on their website if the facts are different. So obviously if you have any queries, then speak to us, your reporting accountant, or there is the professional ethics helpline that you can make use of as well. I think you need to make sure you continue to remain skeptical and question what you're being asked to do by a client, to make sure that the transaction is in relation to the advice that you're giving. You need to make sure that your teams are regularly trained and sufficiently trained, because the accounts rules apply to everybody within the law firm, not just solicitors. So that's everyone down to your receptionists. And if you make any judgment in relation to whether there's a breach or not, just make sure that that's properly documented on the client file. So if it was ever queried by your reporting accountant or the SRA, that you're able to justify the reason why you reached a particular decision. So just going on to the final point that I just wanted to make on the SRA accounts rules before I move on to the tax side of things was interest on client accounts. So we've got rule 7.1, which states that you account to clients or third parties a fair sum of interest on the client money held on their behalf. As we know, in the previous years since COVID, and perhaps even before then, we've seen really low interest rates, and especially over the COVID years, the amount of interest being credited to the general client account was very low. Now we're seeing increased interest rates and increased amount of interest received, so I think it's a good opportunity here to review your policy and just make sure that you are complying with this rule, and have a think about what the policy could look like and when and how often you should be making these payments. So some clients I know credit the interest quarterly to match when the interest is received on the account, and I think that's sufficient. And I've just made another point on there is, you could change the bank to potentially get increased interest rates, but I guess that's a commercial decision, and benefit versus hassle, what I've put on the slide. So yeah. Okay, so that wraps up everything on the SRA accounts rules, but if anybody's got any questions on anything else, please do just pop them in the chat box. I know we've talked a lot about this topic, so I didn't want to cover the same ground that we've already gone through on some of these webinars. So now just going on to the basis period reform, and I call it a whistle-stop tour because you could talk about this for probably about 2 hours, and I don't want to bore you all on this Wednesday lunchtime. But hopefully this is something that you've all heard about. It won't affect all of you, and we'll go through that. But I think even though people have heard of the term, there's still perhaps some confusion about what it actually is, what it means, and the consequences of it for businesses. So hopefully today I can clarify some of that for you all. In summary, the reform is HMRC changing the way that trading profits are taxed. So at the moment we have what they call a current year basis, which means the profits for an accounting period ending in the tax year are taxed in that year. So for example, 30th of April year end, so 30th of April 22 year end would be taxed in the 22-23 tax year, and so on. And we've got some examples, so I'll touch on that again. So that's at the moment, and HMRC want to move to the tax year basis, so align the trading profits that are taxed to the tax year. So why do HMRC want to do this? Get that question quite a bit. So they want to align the way that all types of income are taxed. So you'll know from personal tax returns that if you have any interest income, investment income, property income, anything like that, that's all taxed on a tax year basis. So it's just to bring everything in line. They also see this as a way of helping to facilitate the introduction of Making Tax Digital for income tax, which some of you may know has been delayed for 2 years, so that's not coming in just yet, but ultimately when it does, this should assist with that as well. It will also mean that the taxation of profits and losses or the taxation of profits and the relief you get for losses are aligned much closer to the tax year in which they're generated, so you don't get this big delay in when your tax is due compared to when you made the profits. And longer term, they see it as a process of simplification, which yeah, I think once we get there, I would agree with that. So when is it coming into force? So the changes come in from 24-25 tax year. There's a transitional year in 23-24, so that's starting next week. And that is the hurdle that we need to get over to then align ourselves with the tax year. So we've, at the moment, until next week, got current year basis. We then have a transitional year in 23-24 to then get us to tax year basis in 24-25. So who is affected? So this affects sole traders, partnerships and LLPs. So if there's any limited companies on the call, then this doesn't apply. But any of those entities that have a year-end date which isn't the 31st of March or 5th of April. So yeah, and some potential issues which I'm thinking I'm just going to cover those as we go through it, then might make a little bit more sense. So I've sort of tried my best to set it out on a timeline to explain this. So at the moment, we've got current year rules. So I've put an example on here of a 30th of April year end, which is quite common amongst legal partnerships, and the one that we're going to be seeing coming up soon as well. So as I said, businesses are currently taxed on the profits for the year ending in the tax year. So on the slide, I've got a timeline. So the year ended the 30th of April 22. The 30th of April 22 falls within the 22-23 tax year. So the profits for that 12 months will go on that tax return, which is due for filing the 31st of January 25. And any balance of tax would be payable then as well. As you know, we pay in advance in the previous January and July, but any balancing tax payment would be due then as well. So as you can see, there is a long delay, and the longest with an April year end of when the tax is due compared to when the profits are generated. With the current year rules as well, we also have opening and closing rules which add complexity. So you may have heard of overlap profits, and lots of people don't understand them and what they are. And essentially they are profits that are taxed twice in the opening years of a business, or when a partner joins a partnership or an LLP, for example. And then the overlap profits that are charged tax twice are relieved in the final period. So when a business ceases or a partner retires from the partnership, and then you get relief for them then under the current rules. So that's the situation as it stands today. We're then moving to what we call the tax year basis. So these are the rules that are coming into effect from the 6th of April 2024. So for the 24-25 tax year, a business with a 30th of April year end will be taxed on a proportion of their profits from the 30th of April 24 year end, so the period between the 6th of April 24 and the 30th of April 24. There's lots of dates flying around here, but hopefully you're following. With essentially the period in orange on the screen. So we've got 1 month from the 30th of April 24 year end, and then it would be 11 months from the 30th of April 25 year end. So, and it's not done on actual, it wouldn't be done on actual transactions falling within those periods. It would be done on like a day's apportionment basis. So as you can see, that's not necessarily overly practical, and that's why a lot of firms are looking, if possible, to change their year ends if there's no other commercial reasons why they shouldn't do that. And we'll come on to that in a second. So we've got potential apportionment of profits moving forward, but their profits arising in the tax year is what is going to be paid in the tax year. And as you can see, for an April year end, this isn't too much of a problem, but for year ends that fall later in the tax year, for example, a September year end, December year end, they are going to be more highly affected by this, because if they don't change the year end, they've got a much shorter period of time to get the accounts finalised, to know what the profits are, to be able to input them on the tax return. And if you've got a January or a February year end, even worse, you're not going to be able to know what the actual profits are, which is going to mean that tax returns are going to have to contain estimated figures, and then amendments will need to be required in the following year. So quite a bit of complexity if in some cases if the year end doesn't change. So I think that covers everything I wanted to say on that one. So I think this is the complicated part, is what we refer to as the transitional year, and that is happening, as I said, in 23-24. And in this tax year, what we're going to have is the standard part of the accounts profit. So for an April year end, again, just carrying on with the same theme, we'd have the accounts for the year ended 30th April 24 as the standard part, is what I've referred to. And we would then have another 11 months worth of profit from the 1st of May 23 to the 5th of April 24, so the transition part. So that's 23 months worth of profit taxed in one tax year, and hence why there's a lot of confusion about this, a lot of budgeting required, forecasting for tax and things, and we'll move on to what we can do to spread those profits in a second. So I'm sorry, I'm just referring to my notes. So yeah, so this is where a lot of firms in this period will want to change their year end. So to calculate the transition part, if you're not changing your year end to March, and you're keeping with an April year end, you're then going to have 11 months of that period within the 23-24 tax return. Whereas if you change your year end to March, you've then got a cut off, your software and everything is all up to date, and it's just a case of essentially 2 sets of accounts, or a long period in one return. But like I say, you don't have to change the year end if there's other reasons why the firm can't. So for examples that we've come across, if they're part of a wider group overseas, and the overseas entity dictates the year end, that might be a reason why you don't want to change. So as the overlap profits are going to be removed from the new rules, they need to be relieved in this transitional year, otherwise they'll be lost. So that's where we come on to the next slide. So this sort of just recaps hopefully what I've said. So we've got standard profit, normal tax year, normal accounts year, sorry. We've then got the transitional profit, which is anything after the accounts period up to the 5th of April. And then what we can take off those is overlap profits. And that then forms the transitional element of the tax return. And what we can do is spread those additional transitional profits over 5 tax years. So that means that although there will be an acceleration of tax because the first of those 5 tax years falls in the transitional year, you're not going to have the whole amount within the first year. So this is where it's really important, I think, to compute some of these figures and work with your finance teams, your accountants, get in touch with us if you need any help, and see how you can plan in your cash flow for these figures. In some scenarios, they might not be too large. In some, they can be. We often see that overlap profits are quite small in relation to the profits that are currently being made, because on an individual partner basis, a partner joins a partnership perhaps on a lower equity share, and as they build up to parity over the years, their profit share increases. So the profit share that they're making now is vastly greater than the profit share they did when they joined the partnership. Likewise, if a business starts up, it usually tends to make less profit in the early years of the business. So in most cases that we've seen, there is additional profits because for this. There are lots of other scenarios, and I have just assumed that all periods of profit making for this presentation. But if there are losses, then there are different rules which you'll need to factor in as well. So as I said, you can spread the transition profits over 5 years. To be able to do that, the year end has to be changed within the 23-24 tax year. You can elect, if you want to have more profit allocated to one tax year than another, and if you do this, the extra amount of profit is deducted from the remaining years equally. Likewise, if the trade ceases before the end of the 5-year spreading period, the remaining profit is allocated to the tax year in which the trade ceases. So you would probably, the most common scenario that you'd see that in is a retirement. So say you've got a retirement coming in 25, 26, it might be that you want to just forecast a little bit further ahead for profit, for the taxable profits in that period, and then the resultant income tax that will have to be paid on that. I think it is worth saying this is coming in. However, if a partner was to retire, this would happen all in 1 year. And yeah, that's what happens under the current rules. So the taxation of transition profits. So we've calculated the transition profits less any overlap relief. They would go on to the tax return as taxable income. But it's not sort of all doom and gloom. They are adjusted for the purposes of certain calculations. So the transition element of the profit is excluded for adjusted net income, and the adjusted net income thresholds are factored in when talking about high income child benefit charge and pension annual allowances. So if you're a higher earner and your pension annual allowance is tapered down as a result of that, the transition profits won't be factored in to those calculations. So that's a bit of reassurance, hopefully. We've also then got the personal allowance restriction, so not quite so good news on that side. The transition profits are taken into account for the personal allowance calculations. So if they take you over that £100,000 mark, your personal allowance will start to be tapered down. They can also be reduced by tax reducers, so double taxation relief or investments such as EIS or VCT investments, the tax can be relieved on those. So if that's something that you're considering, perhaps speak to an IFA about that. So yeah, I think that was all from me. I hope that made sense, but like I say, if you've got any questions on basis period reform, please do let me know. And like I say, I think it's just really important to start looking at this if you haven't already, to see what you need to be factoring in terms of cash flow. So I'll hand back over to John.
Brilliant, thank you very much, Ellis. So as I mentioned at the start, I'm just going to cover, excuse me, environmental, social and governance to start with. So just before we go into this, we're just going to have a quick poll, if that's okay. So the first question we just like you to answer, and then just that will guide what we talk about briefly, is does ESG form part of your current business strategy, or does it? Obviously, anyone who's not a business owner, are you aware of it within the firm that you work for? So I'll just give everyone a couple of. Thank you very much. So we've got 44% yes, 33% no, and 22% maybe. So quite an even split over everything there. So some of you may be aware of the ESG concept and how obviously that interlinks with business. I think the ESG concept has been around since 1970s, but has gained significant momentum in recent months and years within social media and the business environment. I think if we look at the slide here, hopefully you can all see the Venn diagram on the left-hand side, to which obviously environmental, how the business minimises its impact on the environment, social, how the business impacts the wider society and its workplace culture, and then governance, processes for decision making and the running of the business. And I think if you then look through the Venn diagram, board accountability, compensation, anti-bribery, diversity and inclusion, health and safety, waste management, I think ESG is a really good framework to look at how your business is run and look at where areas that you might be able to make amendments to like your business strategy going forward. So hopefully that's just a very quick whistle-stop tour as to the ESG concept. With regards to the environment, which is probably the area that people focus on most within the ESG framework, we've obviously got carbon impact on the planet. So large companies are already within scope for carbon and energy reporting and have to include within their strategic reports scope 1, scope 2 and scope 3 emissions, to which on the slide here we've just got the definition from the GHG protocol on the types of emissions that are included within each scope. So broadly, scopes 1 and 2 are the direct and indirect emissions that are generated or purchased from assets that the entity owns. Scope 3 is then indirect emissions from anything else. So obviously for most businesses, particularly in professional practices, the largest carbon impact is commuting, to which if the vehicles are owned by the entity, they will fall within scopes 1 and 2. If they're not owned by the entity, they will fall within scope 3. Obviously, appreciate that probably not a lot of you on the call today work for large organisations and won't be in scope for carbon reporting at the moment. But I think with the way that the regulation is changing, the additional disclosures, particularly in Pillar 4, that large and listed entities will have to do going forward, hope you will see that their scope 3 emissions, which is where include both their upstream and downstream, so what they acquire from their suppliers, to which obviously your customers may be large businesses, you will then fall into scope probably much sooner than you think in this sector, purely by the requirements put on the larger businesses. Sorry, just moving on to the next slide. So as I say, ESG is a huge topic that has had significant increased coverage in the media recently. And also, I think it's fair to say that its focus within the business environment is also gaining significant momentum at the moment. So as I said, you look at the increased regulatory reporting requirements for large entities, to which small entities will have to report to their customers in due course as part to ensure that they can do their reporting. I think if you look at locally as well, you look at on the procurement side, for instance, Sizewell C, I know that every single supplier, even if it's the company providing food and drink to the project, they will have to give details of their sustainability accreditation plan and their net zero details, as Sizewell C will be a net zero project. You then look at Norfolk County Council, they've produced their draft white paper on net zero by 2030, to which then that obviously factors in local schools, to which any new build school will need to be net zero as well. As such, where you're doing work, particularly with public entities or larger bodies, I think more and more very soon you'll be asked to provide sustainability credentials or details on carbon impact to your customers. So I think the earlier that you can get a grasp on the ESG framework and obviously this reporting, the better, because I think it will just be the standard norm in business going forward. on that slide as well, just in relation to its position and priorities as we stand in 2023, I think a lot of professional practices employ trainees. I think there's a much greater awareness and a priority within those people within your organisation. So you may get asked during recruitment days whether ESG or is part of your strategy there. And I think from the banking side, and we're really starting to see as well, green investment. So lenders looking to invest into businesses that are seen to be sustainable. And as I say, you may, where you work with your banks at the moment, particularly where there is significant lending, you will be asked for your credentials going forward. So as I say, there's a huge framework. There's so many things to incorporate within there, but I think, as I said, it will become the norm going forward. And I think it is a really good framework to review your business strategy and look at where you can maybe get a competitive edge over your competitors. So that's everything I wanted to say just in relation to ESG there. The final poll, once again linked to ESG, is we've talked about the framework. Just want to ask, is anyone working towards a sustainability accreditation? So I'll give everyone 30 seconds. Or obviously, once again, if you're not a business owner, are you aware that your firm is either accredited or working towards an accreditation? So 13% yes, 88% no, which the accountant in me says that's 101%. So not sure what's gone on there, but we'll assume it's 88% and 12% potentially. So as I said, obviously ESG as a framework, there are a number of various different accreditations within the ESG sector, to which I think B Corp particularly is probably the most notable and well-renowned accreditation globally at the moment. There's over 5,000 firms who have signed up to that. That looks at, as I say, not just the environmental impact, the social and the governance, and you're asked to look to attain a score based on your current business practices as to how sustainable your business is. I think if anyone is really interested in ESG, looking at B Corp is probably a really good place to start, as the initial assessment is a great tool to benchmark things that you could be doing within your business, as I say, as part of your employment proposition, what you do with the community, or particularly obviously the environment. I think the key thing obviously with the economic position at the moment, broadly speaking, if you cut carbon, you're probably cutting your costs as well. So there's probably many reasons to look at ESG at the moment. Just moving on to other priorities, and then we'll go on to the question and answer session. So I think some of these coming up on the slide are not new. I think they will always be a key focus to any professional practice. I think it's just making sure that they are reviewed and updated on a regular basis. So obviously time management, there's various different ways you can slice and dice your people's time. We quite like to look at it as client service, team and firm development, and then personal development. I think the key thing is obviously one, collating that data, and then when analysing it, making sure that where you do analyse it, it ties into then the business strategy or individual people's development plans or appraisals. So obviously continue to monitor that. With regards to work in progress and cash flow, obviously always important. I've talked about that on numerous webinars, but I think particularly going back to what Ellis was saying earlier, those firms that aren't a March or 5th of April year end, where they will have this basis period transition, the impact on cash flow, even with the spreading rules, will be significant. So ensuring timely budgets, looking at the cash flow forecast and determining how will that extra cash outflow be funded. Is it going to be additional partner capital injection? Is it increased banking facilities, or could you eke more out of your existing working capital? people and succession and key personnel, I think, as I say, they're always a never-ending cycle. So just making sure that you do continue to focus on those, even if you may have gotten over a small succession issue in the immediate time. Obviously, looking down the line, further issue may arise. And then just on regulatory changes, we talked about this actually on the webinar last year with regards to accounting standards. The financial reporting exposure draft is out at the moment in relation to IFRS 16 on leases, which we talked about last year, where in essence all leases, unless they are small in nature, being time or value, will be brought onto the balance sheet. That is highly likely to go through and will be for periods commencing on or after the 1st of January 25, with a restatement of the previous period. Therefore, December 24 will be the first period that comes into effect. Like I say, that's just out for final consultation at the moment, but the ICAW and the FRC have strongly indicated that will go through. As we said last year, I think it's just looking at if you've got any covenants attached to bank debt, how will the IFRS 16 impact those? And then finally, just on Companies House reform, which we did talk about last year, that is also going through at the moment. And obviously for any LLP limited company, which is registered at with Companies House, micro, small businesses will be filing their profit and loss accounts and a director's report at Companies House. Therefore, obviously, potentially how you manage that information going onto the public record, do you need to consult and speak to your people before that actually hits the public record in due course? That was everything from myself on ESG and obviously other continued business priorities. So we will open the floor out to any questions. So if you do have any, obviously on the back of that, please type them into the chat box. We've got a couple of questions so far. So the first one is other business priorities. Where do you see these at the moment? I don't know, Ellis, if you want to talk about cyber or you would like me to talk about cyber. Yeah, sorry about that. Yeah, Ellis is spot on. I think cyber risk is constantly evolving, never stands still, and probably, as Ellis has noted, is top of the business risk register. And I think particularly in relation to PI renewals, which are probably coming up again soon, I think the level of questions that your broker or the actual insurer will ask you are only ever increasing. I mean, last year we saw huge increases in the level of training that you provide your people, multi-factor authentication, closing down of how quickly you close access rights down when somebody leaves, and so forth. So yeah, I think it's a never-ending task. The other question is just in relation to B Corp and the cost of it. So as I said, there's a free initial assessment you do where you answer several questions on your business in each area. After that initial assessment, you then go through, if you can demonstrate a score of 80 out of 100 on their accreditation, you then go through for a formal application where they review all of the data behind your application, and it's £12,000 per annum there. It's quite as I said, it's the most renowned accreditation currently within the business world, and you have a nominated legal representative within the firm who takes responsibility for compliance with the accreditation.
Sorry about that. Apparently after 3 years of remote working, I can't get my head around being on mute and not. So no, sorry, I don't know what you had in relation to that question.
Perfect. They were all the questions we had. So obviously, thank you very much for attending during your lunch hour. If you do have any other follow-up questions, then please reach out to Ellis or I, who would be more than happy to chat through all things SRA, tax, business strategy, and anything else. So thank you again.
Thank you, everybody. Have a good afternoon.